I'm David Pyke. I'm a lawyer that practices in the field of probate and guardianship work. I've been licensed in practicing law for approximately 25 years now. I was a graduate of SMU Law School, have an accounting degree from Baylor University, and I've concentrated in this field of law exclusively for a decade now. I handle hundreds of cases from routine to complex and disputed matters in this area. The common question that people have is, do I need to probate the will if a loved one has died? You need to probate a will to transfer assets, mainly real property, bank accounts, or things like that that are not automatically transferred or do not automatically become the owner of the heirs. Real property is almost always required to go through probate. The purpose of probate is to create an orderly transition of an estate, to provide a way that people know who they're dealing with to the estate if they need to settle up debts, or if they want to buy the property from the estate, then they know who to deal with. So a person is usually appointed, name an executor or an administrator to handle the estate. So it's a very logical process, and thankfully in Texas it's an easy and streamlined process. A will does not have any impact until it's probated. So just because it says these people get the property, it doesn't have any legal effect until it's probated, until the court says, yes, that is this person's last will, it's not been challenged, and we enter an order saying that the will is probated. So that to probate a will is to say it has legal impact. And so you can't just read the will and say, well, it transfers the assets. If you take a will to a bank and say, give this money to me, they will decline. They will ask for letters, meaning letters testamentary or letters of administration, and that's what you get when you probate a will. I mean, by and large, most of the probates I file are uncontested. We probate the will, nobody contests the will. We get an order that the will is admitted to probate, and the person that's named in the will as the executor is appointed as executor, and they get letters testamentary, which is a document from the clerk that evidences that this is who I am. And then they can go off and handle the estate, and they usually handle the estate at that point without doing anything further to the court except an inventory, and without any further assistance from our firm or from any lawyer except to do that. And that's called independent administration, and that's authorized by most wills and is available in some other types of estates, and that you are able to wrap up the estate and do all the business part of the estate, selling property, paying debts, closing accounts, without going to the court and asking permission. So once the will is probated, the process of running the estate usually is pretty streamlined and inexpensive.